And they created a charter in which they decided, we're not going to just execute these Nazi leaders. We might, that might come at the end of a process, but we're going to get there by law. We're going to say that the Nazis decided that law didn't matter, right? Or the law was what we say the law will be. Because in a weird way, the Nazis were an extremely bureaucratic, sort of law-based, even though it was a deeply illegitimate kind of law. It was a bureaucratic organization. We're going to say that kind of lawmaking is not appropriate. The international community wants the rule of law, and we want accountability for crimes against humanity, war crimes, and crime of genocide, essentially. So Justice Robert Jackson, who's here in the corner there, he served as the leading justice at Nuremberg. And though we now generally see these trials as a triumph of law over vengeance, at the time, and even today, we see this discussion of people who wonder whether this was really just a form of show trial, or if it was really a kind of victor's justice. In fact, at the end of Nuremberg, after the essentially 1 year, a little bit over a year-long trial against 26 senior Nazis, 3 were acquitted, 12 were sentenced to death, several others were sentenced to terms from 10 years to life in prison. Nuremberg was then followed by a series of trials in the military sectors of Germany following the war, including U.S. military tribunals that tried a number of Nazi leaders. And then they were followed even after that by trials in domestic courts around Europe. And even just this past week, we see the continuing relevance of the Nazi era in the deportation of John Demjanjuk, who's accused of running the Sobibor camp, sending him back to Germany. But no tribunal, no system of international justice followed for essentially 50 years. It was Nuremberg. Nuremberg was over, 1946. Individual countries were able to do their own thing for a number of years. But until 1992, 1993, there was essentially nothing that went on in the world of international justice. There was a lot of thinking about how we prepare for the time when we might have courts that could bring accountability for these kinds of crimes. But essentially, there's a moment that's frozen in terms of international law, and that's 1946 with the trials in Nuremberg. Today is much different. So I want you to fast forward from 1946 in Germany all the way to Bosnia in 1992. Anybody who looks at the international response to the war in Bosnia can really only conclude that the international community was essentially hamstrung. Right? It didn't know what to do. It didn't want to intervene militarily for fear of losing their own soldiers. Right? So we're talking essentially NATO, European states, the United States. We didn't want to intervene. And it was clear also in the context of the end of the Cold War that we weren't going to be able to get authorization. That is, the West wasn't going to be able to get authorization in the UN Security Council from the Russians in order to intervene in Bosnia against the Serbs, or in Croatia against the Serbs. And so there was essentially inaction in the international community. There were little band-aids here and there. There were safe havens that were created in towns and cities throughout Bosnia. But if you go all the way to 1995 to Srebrenica, we saw that these safe havens were anything but safe. They resulted in they were essentially overrun by the Serbs in time. So in 1992 and 1993, there started to be this thought that, well, if we're not going to do anything in terms of military intervention, and at the same time the United Nations has imposed an arms embargo, so we're not even really allowing the Bosnian Muslims to fight back in the war. If we're not going to do any of those things to actually stop the war, let's at least assert our abhorrence of the tactics that are being used by the Serbs, and really on both sides, but if you look at the numbers, more by the Serbs. And so there starts a process in 1992, 1993, to create an international tribunal that is modeled more or less on Nuremberg. So it's the legacy of Nuremberg. Nuremberg, that legacy has been more or less dormant for 50 years. 1992, Europe sees the worst crimes on its territory since World War II, and they decide, well, let's see if we can create something that actually takes from that legacy of Nuremberg and create international justice for ourselves. And so the United Nations in 1993, during the Bosnian War, says we're going to create an international tribunal. It's going to be able to punish war crimes, crimes against humanity, and genocide. 1994, what happens in April 1994, which begins in April of 1994, in the period of 100 days, is violence that the world really hasn't seen on a scale since Pol Pot in Cambodia, and that is the genocide in Rwanda. Right? Within 100 days, somewhere between 500,000 or 600,000 and 800,000 Rwandans are massacred in really the most brutal ways. The United Nations, which had just created the ICTY, the Yugoslavia Tribunal, decides to create the ICTR, a tribunal for Rwanda. Okay? So these are tribunals that are created that are ad hoc. They're created to deal with very specific situations, specific crimes, specific conflicts at a specific moment in time. 1993, ICTY, 1994, Rwanda. And the international community starts to see, hey, this is something that is, one, needed. We've got all these massive conflicts going on around the world. But at the same time, every time we create these institutions, it's expensive. Right? We're creating institutions in The Hague. For the Yugoslavia Tribunal, we're creating this institution down in Arusha, Tanzania, the Rwanda Tribunal. At this point, the ICTY has cost $1.5 billion, give or take a few hundred million. The Rwanda Tribunal isn't far behind. These are very expensive operations. It's already seen that that's true in the early 90s. And so the international community, mainly activists, but also some governments, start to push forward for a permanent international court. Why do these ad hoc things? Why not have one that's permanent, so whenever there's conflict, we can have a standing court that can deal with these kinds of crimes? That's the International Criminal Court, which gets a statute. It's approved by over 100 countries in Rome in 1998. And there's the Rome Statute. Famously, the United States didn't vote in favor of it. We can talk a little bit about the reasons for that. But the ICC now exists. It has existed since 2002. So the statute was adopted in 1998. 2002, it enters into force when 60 states have agreed to it. Now it's 108 states. Sean Butler, in fact, who's the head of the International Criminal Court Alliance or Coalition in Los Angeles, is here with us today. It must be about 108 states that are party to the International Criminal Court. And it's a very real institution. It's pursuing cases against the Lord's Resistance Army, which is this brutal organization that operates in northern Uganda. It's pursuing cases in Darfur, as I've already mentioned. The Democratic Republic of the Congo, which is really one of these kind of quiet genocides that has occurred. Not so quiet for the people who live there, but the numbers are in the millions in terms of people who've been killed in the Congo, up to perhaps 5 million. And the Central African Republic, they're pursuing a case as well. Since that time, since the mid-90s, we've had other tribunals. We've had a tribunal that's been established for Sierra Leone. So following the violence in the mid-90s there, a special court was developed. A special court was also developed for Cambodia, dealing with the crimes of the Khmer Rouge. These are not ad hoc tribunals created by the UN, but these are tribunals that are created by agreement between these states and the United Nations to create what we call hybrid tribunals that are a little bit international, and that they have international civil servants who are involved in helping prosecute cases, but they are creatures of domestic law as well. They are part of the domestic criminal justice system. And there are other courts as well. I also included domestic courts down there, a little picture of the U.S. Supreme Court, because even though we're talking a lot about, at least I'm talking so far, about international tribunals, obviously these are the kinds of crimes that can be tried in domestic courts at the places where they occur, and there's a large school of thought, a very vibrant school of thought, that in fact that's where all of these crimes should be tried. They should be tried by the victims, essentially, by those, by the places where these crimes actually occur. Right? Bring the justice closer to the people who suffer. But domestic courts around the world can try cases as well. The United States courts, under something called the Alien Tort Statute, can actually impose civil liability on torturers and others who are responsible for crimes against humanity and war crimes and such. Anyway, it's important to keep in mind that although we're talking about international tribunals, these are the kinds of cases that can be tried in domestic courts as well. Who are the defendants? Now, this has been a big problem for the ICTY and the ICTR, the Yugoslavia and the Rwanda Tribunal. It's clearly an emerging problem for the ICC as well. Do you go after and try what in the Yugoslavia Tribunal they used to call the low-hanging fruit, right? The people who were the trigger pullers, the people who, they don't have the protection of a political party or of organized crime the way some of these big-time leaders, political leaders, have. But they're easy to capture. It's a lot easier to capture, a guy like Boris Tadic, or Dušan Tadic, who was the first person who was arrested and sent to the Hague for trial by the ICTY, the Yugoslavia Tribunal, because he was traveling in Germany. A Bosnian Muslim recognized him as someone who had been at a camp that this guy had passed through and been maltreated at. He's arrested in Germany and sent to the Hague. That's not going to happen to Slobodan Milosevic, right? It's not going to happen to Radovan Karadzic. There's other ways of getting at those people, but it takes a lot of time and a lot of effort and a lot of energy. Over time, it's become clear to the international community that these courts cannot be used really for trying what I'll call the low-hanging fruit. Right? There are just too many of them. Right? In Bosnia, for example, where, let's say, conservative estimate of the numbers of people killed during the war is somewhere around 100,000. The figures are really 100 to 500,000. But let's, even using the lower numbers of 100,000, that's not 5, 10, 15, even 200 people killing, right? That's thousands of people committing crimes. The estimates for Bosnia that there are maybe something like 3,000 or 4,000 individuals who committed some kind of crime during the war. I don't mean just any kind of theft. I mean a war crime or participating in a crime against humanity. Are you going to go after all those people? You might, but that's going to be really expensive. Only 161 people have been indicted by the Yugoslavia Tribunal. 161, and it's cost $1.5 billion. Right? So we're not going to be going after all of those people because it's going to make that $1.5 billion number really pale. So instead, over time, the international community has realized that you need to essentially divide up responsibility. Right? The international community can go after the senior level people, right? Essentially to make an assertion of values. Right? If you're going to be a leader of a country, you have to adhere to certain norms, and if you don't, and if you commit these kinds of crimes, you're going to be tried by the international community. So we see Radovan Karadzic. There he's standing with, if you can see it, I know it's small back there, but he's standing with Ratko Mladic, who's really the last remaining big fish for the Yugoslavia Tribunal. He was the general who was really most responsible for a lot of the carnage during the war in Bosnia. There he's standing with him during the war, and then he's in the dock awaiting trial. There he's on some procedural matter. Below is Charles Taylor during the war, and then afterwards here he is now where Charles Taylor is undergoing trial at the Special Court for Sierra Leone. Below there is Doik, the man I mentioned, who was really torturer in chief for the Khmer Rouge during the war in Cambodia. The international community goes after those types of people. We're not going to any longer see trials at an international level of the low-hanging fruit, of individual soldiers. Now, it's possible we might, if those individuals commit such massive crimes that they can really only be tried by an international tribunal. But the focus on individuals more and more is being left to domestic courts.